5 seconds to go. Start. Mr. Vice Chairman, sir, I am very thankful to you and the honorable members who have participated in the discussion. I have heard with great attention the various speeches made by the honorable members in the foregoing debate on this bill. Before reacting to the individual points made by the honorable members, I would like to say that the present amendment bill cannot be deemed to be a recodification of the entire Companies Act. This bill incorporates provisions of an urgent nature which have to be brought not only for the effective regulation of the corporate sector but also for its smooth functioning. The corporate sector encompasses various sections of the people and not only companies and their management. We have to protect the interest of the shareholders, the depositors, employees, public interest, while also looking at the interest of the companies and their management. If we go carefully through the various provisions embodied in the bill, you will find that the different provisions have taken care of the interests of different sections of the people. While on the one hand, there is a forum being provided to depositors whose deposits are not returned by companies on time. On the other, the interests of those who apply for shares in a company are also being protected by the provisions relating to the refund of the application money when shares are not allotted. It has also been made mandatory that the company will deliver share certificates and debenture certificates within a prescribed period of time. Similarly, when share transfers are refused and there is a dispute, provision is being made that pending settlement of the dispute, the transferee does not lose his rights over the dividends, right shares, bonus shares, etc. All these provisions are aimed at protecting the small investors and shareholders also. My friend mentioned about non-furnishing of annual reports to the shareholders. It is not that we are not concerned that information needs to be furnished to the shareholders. However, it is felt that as average shareholders may not really require all the information that is published in the annual reports today. My friend himself stated that the list of the employees drawing over a certain amount of salary can be done away with. It would be evident, therefore, that he shares the view that all the information may not be essential for an average shareholder. Sir, it is therefore fully in order that the company should be asked to supply only such information as may be prescribed by the government to a shareholder in the first instance, and only those shareholders who really require the entire information in the annual report should be provided with it. As the proposals in the amendment bill and the further amendments suggested will show that this full information can be obtained by any shareholders on demand free of cost, it cannot therefore be said that the interests of the shareholders are not being adequately safeguarded. So far, the small depositors whose deposits were not being refunded by the company in time had no remedy under the Companies Act. He had to go to the civil court to enforce his claim. We have provided in this bill that a depositor whose money is not refunded in time can approach the Company Law Board, which, after looking into all aspects of the matter, can direct a company to repay the deposit on certain conditions, and if the company defaults in obeying this order of the Company Law Board, it is able to be punished. I am sure all the members would agree that this is a major step towards the protection of the interest of the depositors, particularly the small ones. It will be seen that in various existing provisions of the Companies Act, there are specific limits prescribed, such as the ones for disclosure of salaries above a certain amount, compulsory appointment of managing director, etc. With the passage of time, many of the limits become outdated and need to be changed. It is felt that flexibility in these matters would be of great benefit, and with this aim, it has been provided that these provisions be changed to such limits as may be prescribed by the government. My friend has mentioned that instead of the present provision that a managing director or a whole-time director be appointed in a company with a paid up capital of rupees 25 lakhs, that limit should be raised to rupees 5 crores. The provision that we have proposed in the bill and the amendments that have been moved will take care of this problem. Whether the limit should be raised to rupees 5 crores can be determined from time to time, taking into account all the circumstances. Some of the provisions relate to the removal of the lacuna are observed, and it is seen that undue advantage is being taken by the company to avoid the intention of the law. Such a lacuna must be removed for the benefit of the shareholders. Now, stop.